Looking at Intellectual Property Act and piracy, there is the act, but why is piracy still a big trouble for creatives?
Well, intellectual property enable rights, ownership of original idea, prints, audio, visuals that emanate from the rightful owner and creator of such rights, such content. And unfortunately, we are faced with this either situation of piracy, uh, even stealing of artworks. Um, there's been a lot, even lack of payment of royalties from media organizations to intellectual music owners or movie owners and all this. So these are a lot of mixed issues centered in one. Very important we understand that the way we are wired in this part of the world, rule of law have not been part of our system, and that is why you go to Alaba market, no matter how the clamp down is, you still find these imported CDs, you still find these people work, even a new work of art, books are being pirated, nothing that even as far as we all know, even drugs, everything that you see the original, that you have original, you have seen a whole lot of those pirated and copies or fake copies, or how do we, no matter how we relate it, but it's a criminal act. And you know, it's just unfortunate that the police ought to take a whole lot of responsibility in serving as a deterrent in punishing those that commit this type of heinous act. Because when you commit intellectual property, you are killing a vision, you are killing a family, you're killing a society, and that will impede development. And these all syndicate groups have they are big men in our society. If you see them, you think you're seeing human being, but that is what they do. So it's quite regrettable to begin to talk about this issue. And in view of the anti-piracy laws and the task force from the various organizations, no matter the burning of fake CDs, arresting the boys on the on traffic, the way things go, you still see a whole a whole new line of business, because this is a line of business for the criminals. So the best way we can is what your media house is doing to begin to talk against this Unions Act and call the attention of the government at all levels. Because for us to end piracy is a collective responsibility between the government and the governed.
Join us once again, Areola Dotun Hazan. I would like you to, as a legal practitioner, because of your legal background, take us through the processes involved when you need to copyright an intellectual property, and then you also talk about the time limit. How long do you hold the right to an intellectual property?
Well, the basic thing is that it's because of the way we are reasoning in this part of the world. For every owner of an idea, for every owner of a music work, for every owner of a book, for every owner of a of a content with the copyright with the Nigerian Copyright Commission, we have the Ministry of Trade and Commodity, whereby you can as well do your patent and trademark, because these are ideas. People really understand that even your logo, you need to trademark it and register it. Your artwork, your books, you can register it with Nigerian Copyright Commission. You can go to Federal Ministry of Trade and Investment to do registration of trademark and patent. These are areas. Copyright are works, books that needs to be protected by the original owner. All you need to do is to have your work, take it to the Nigerian Copyright Commission, get it registered. Then if you also equally and other key areas of registering your book or artwork, is through the ISN number for library and all that. You also need to register that work. But in view of all this, the the syndicate involved in this crime will copy and paste all those things that you register the way the original work is being done. That's what they sell. So even you that hold the idea might not even make half of the money they are making in the production of your artwork or your books. But it's very important that you get it registered so that where and how even your music work, you need to also do a whole lot around it. Videos, you see a lot of work. If it is visual, you go to the Nigerian television and censors board to get that really censored so that it can be registered. For there are different lines of registering your intellectual property, your idea. So, but the best way you can really, as the owner of an idea, is to get a legal practitioner to be by your side. And you can see similar situation whereby if you look at the mobile case now, is much of intellectual work is not properly protected. It's just loose and had an open-ended, unprotected intellectual right, whereby the family is to accept his royalty now will become an issue. So, because even the agreement that some of these label companies sign with intellectual property owners and music owners or producers or writers are inchoate. They are more like intended to be fraudulent in one way or the other. But for a proper right of the owner of that idea to be protected, he needs to get his own personal lawyer. Because when you have your lawyer will know at every particular stage to protect your right. Whenever it's been violated, whenever your intellectual right of originality, what intellectual property protects is originality. So, and that becomes yours. If you have a logo, you do a trademark of the logo, and that's where you see a sign of R in a round circle. That means it's a registered logo. You see that of some brands and companies. You see that sign on their logo, so that people don't mimic or try to copy or redesign or mutilate that logo. So that's just what it's all about.
Okay, for intellectual property owners and particularly those who are in the creative industry, having their work distributed or disseminated in different ways also help their works become popular. What's the way to go about it while you also ensure that you retain copyright? Your works can also be maybe used by other people, and it goes to different places that you may not be able to use these works. For instance, a musical work. You have the songs being played at different centers. Even currently in Nigeria, there is the copyright, there is a body that ensures that those who are owners of lounges, who are owners of hotels and different places cannot play the song of an artist without registering first. Is that too much, or is that the way it should be? That even before you play the song, let's say at an event as a DJ, you must have registered to be able to use that song. Is that what copyright is about, or it's been overstretched?
No, what copyright is about is to protect the originality of your named work, either books, music, videos, written history, and everything that you can initiate or innovate as far as life is concerned. But the way, because of the high rate of piracy, high rate of non-payment of royalty. You see unions of various intellectual owners from music world, music P-Man, writers association. everyone trying to come up with a way out in protecting their works, and that is where they come up with their own policy plan and driven ideas that will galvanize this interest. So for me, the is not actually a one size fits all situation. It's all about how they can initiate ideas. So majority of what you see, oh, you as DJs, you need to register. Who is monitoring the DJs in various clubs at night? Who is to ask them? No one. There is no policy plan. There is no means of galvanizing this whole idea together. So it's more important that there must also be a new law that regulates the use of works, how these works needs to be paid for. If you are having your works and it being heard on radio or TV or from, you need as the owner of that work, because you are they are earning value for the content which they are displaying. But the owner of such work, although some of these media organizations do such, but not all, because you even need to go and beg a radio station and pay them to use your work, which is supposed to be the other way around. Most people take their work to beg DJs to even play it for free. They pay them to pay, whereby it's supposed to be the DJ to collect to pay the owner. So there's a whole lot of anticlimax in this whole situation until there is funding, there is protection for the owner, for originality, for idea, and the government needs to create some incentives and galvanize this whole institution so that it doesn't just end in the hands of quack. It doesn't just end in the hands of a producer or a marketer who will at the end of the day kill the owner of the idea. We have seen it even in the time in the old days of King Sonny Ade. He also had similar issues with his record label. We are having similar issues with a lot of musicians with their record label, because by the time they get into this whole agreement, once they get into the middle, a whole lot of breaches comes in. So, but no one to protect the owner of the idea. So even the police don't know how to interpret some of all these ideas because they don't know how to treat them. There is lack of knowledge, detailed knowledge. So there is a need for collective orientation. There's a need for training of the law enforcement agents to know how ideas need to be protected. There is a need for means of payment of royalty to record labels and the direct owner of that idea to must be beneficiary, principal beneficiary of idea. But most times, the record label might take 90% and give the owner 10%, which are Shylock ideology. So we cannot, there is a lot of huge gap of challenge to cure this anomaly called intellectual killers. So we need to do a whole lot more. And that's one of the commendable strength that I must commend your media organization for taking it up and discussing this vital issue.
Let's look at the issue of payment of royalties when it comes to intellectual property. I would like you to talk to us from your observations. What are the challenges associated with getting royalties? And then what are the procedures, when it comes to getting this money? What determines the value? And what are the rules guiding payment of royalties in Nigeria?
Well, the payment of royalty are expected income a property rights owner, intellectual property owner gets from the work of art that is being used or being sold or being exhibited by the user. And the user, it can be either a TV station, a radio house, DJ, clubs, hotels, and wherever those works are being used. The most fortunate is that the royalties differs in terms of what the owner of an intellectual work is expected to be paid. There is no one size straight amount that you are supposed to pay, but an aggregate of such, and that is the key area that we are lacking on. The discretion to pay royalty are left with the user to determine a quantum merit. A quantum merit means a reasonable amount can be at the discretion of the user of those idea. And most of the time, because of the total neglect, because of the pressure from the original owner of such works, they are not actually paid what they are expected to be paid because there is no particular percentage, because there is no way they can value the work of art. Work of art are different. You can see a work of art or a music that is rated higher, and then you can see a work of art that is just an upcoming artist. So the ratings are different. But because there is no layout plan, so the basic area that majority of original intellectual works are getting their pay, and they get it right, is through the online downloading process, through Netflix, through different platforms that can sell this idea. And once you download from the internet, money being generated through the online process, they get their money directly through YouTube, through this whole account that people actually use. And because there is a count of viewers, they you get your payment according to the viewers of your artwork, the amount of traffic you generate. And you just see a lot of people on the social media now, through Twitter account, through their Instagram, through their various social media platforms and handles. That's where they make their money from, because that area is a growing area. But because of the payment model, is a well structured and well based system that people can easily access and get compensated for. But from our own part of the world here, we are here to design a a strict regulatory standard plan, because of one of the impediment is poverty, lack of basic infrastructure, lack of funding, because even the owner of the intellectual work must somehow borrow money from banks, from family and friends before that work of art is being promoted. And once those are not properly meeting the desired expectation of the promoter, they don't. And there are a lot of things that equally go underlay. There are a lot of underlays whereby for you to be featured in movies, there are a lot of issues people complain about. These are areas of regulatory interest, not just the royalty alone, but the desired expectation, fulfillment of that intellectual right owner is not protected as far as we are concerned. But there is a way out. The way out is the fact that the laws are there that recognizes payment of royalty. The intellectual property laws, the policy formulation. There is a policy formulation that recognizes that. But the major thing is the enforcement, the implementation of this whole idea. There is no proper way that the users of original works of people don't see reason to commit themselves into payment, maybe for lack of a necessary instrument of payment. There is no connect. There is no line of the consent of the owner. Before you even use that work of art, you need to get a written consent of the owner. But in this part of the world, everything goes. You just see person using your work. Even the person will expect you to thank him for even using your work. But at the end of the day, he has used that work to make millions of money. He has earned views. He has earned traffic. And these are areas that we need to really consider together. But for because there's no proper line of payment, people come into mutual agreement of ADR, alternative dispute resolution, arbitration, to look at how do we have a win-win situation. They negotiate. You need to negotiate to get something, and that is at the discretion. Most of the time, are quantum merit, meaning there is not even a reasonable amount. Anything goes that can just satisfy the hunger of the original owner of such works. And it's really unfortunate that we're having such a unequal and breach and a violation of intellectual rights owners.
All right, let's look at trade secrets as an intellectual property. What would qualify an information about a business as a trade secret, and how can businesses protect their trade secrets?
Well, trade secrets are what quality that made your brand, either a product. Let's say you have a drink, you have a there are a lot of things that we are talking about here now. Owners of brands knows how they prepare their product and gives them the desired taste, and those that buy such product know that, oh, if this is not this, it cannot be this. So I wouldn't want to be naming companies and ideas, but trade secrets are that specialty that makes your product different from the others. And the way that you can rightly protect it through NAFDAC, through organizations that regulate your product, through SON, that is the regulatory agencies that register products that are consumable products, and these are areas that if your products are not registered with NAFDAC and properly recognized and well processed with SON, there is no way you can make up a case for violation of your trade secret. Maybe someone knows how you are doing this and they imitate it, that same taste, but they give it a different coloration. But the fact that that thing belongs to you, there is a way you can fight it by petitioning the regulatory agency to look into the violation of your trade secret, of your production right. And if that's why you see some products in the market now, they tend to mimic names that were mostly closer to those products. But most of the time, the products don't actually taste like that of what you want. Maybe you are drinking cola now, either of the cola that you want to drink. You want to compare which one is more different, which one is lighter, which one is this. Because people goes into different areas to have distinct taste for their product. But these are another areas. If just as I rightly said, there are regulatory bodies for different ideas. When we talk about intellectual property, these are contents that you innovate yourself. It can be consumable products, it can be IT idea in the IT world, in the information technology, it can be book, it can be music, it can be anything you can think and process and mix it into a reality that is tangible, that you can own, that this belongs to you, that you know that no one else have done such a thing before. But these are criteria that you just have to look at. Registering those things first makes you that gives you a first-hand right to challenge any violator of such. If there is any means that people goes out to imitate your product, or even maybe we have seen in some certain scenarios, expensive wines are being and consumables. You see a lot of fake consumables, expensive wine being distilled by fake people. They have it in one corner of the shop. You see bottled waters that are being distilled in one corner of the shop by picking the empty plastic and just putting ordinary just bottled water, and they sell in traffic. These are whole violation of the owners of those products, of the original owners of those products. So there is still a whole way that the government needs to come in more. The government needs to play a lot of orientation role. There's not a lot of information in the public domain that the public need to digest, because owners of ideas fall victim because they don't even know their rights. There's no way, and there are limited lawyers that even goes into such areas of practice. So it only requires your commitment. Even in sports, there are a lot of areas in entertainment law. We have entertainment law. We have different diverse of areas that people can begin to explore. And there is a need for more orientation. There is a need for more seminars. There is a need for more information through the National Orientation Agency that will ensure that people's rights within these kind of areas that I've discussed. If you have books, you go to copyright, the, maybe the Nigerian Copyright Commission, get your original work, fill the necessary form and pay the right fee, and you get your certified certificate for that product. If you are having consumable, you go to NAFDAC and son, they will test your product, know that is health and hygienic for consumption, is otherwise okay for consumption. Once that is certified okay, you get a number that will make you the rightful owner of that product. If it is for a trademark, you go to the trademark into the Ministry of Trade and Investment in Abuja or any of the affiliated offices. Then you get your idea, your logo protected. If it is video, you go to Music and Video Censors Board to make sure that your work of art is certified okay in terms of the age, in terms of the content. But now you go to social media, no regulation. You see a lot of obscene things that have been thrown into the social media because it's not regulated. And if this the way things have been being thrown into the social media world, not properly regulated, we'll just wake up one day and our children will be taking hints of the things that are being thrown out there because of the way people just want to make money and they just want to make content that will attract more viewers. Because of selfish interest, the society would have been half destroyed. So there is a need for the National Assembly to regulate the social media. I was made to understand some at the 8th or assembly, there was a need to promote the regulation of social media law. A lot of barrage of attacks were being thrown into the National Assembly. We had it in Lagos too, when Desmond Elliot wanted to also raise such a thing. He was attacked